Okay, part 4 of chapter 23, adjudication. That's the third thing that agencies do. Rulemaking, adjudication, and enforcement. Okay, so after conducting an investigation of a suspected rule violation, an agency can initiate an administrative action against an individual or organization. Most of these are resolved through negotiation. Oftentimes, alternative dispute resolution is used. Some end up in formal adjudication. Okay, so let me start off by saying that it's not only enforcement measures that end up in adjudication. Other things can as well. For example, Social Security. Let's suppose that you become disabled and you apply for Social Security disability. The agency has rules on what is disability that allows you or qualifies you to receive Social Security benefits. So if you're turned down by Social Security for those benefits, you have a due process right to a hearing. And so that's another adjudication process that agencies go through. All right. So a negotiated settlement in an adjudicative process depends upon how the agency operates. They may be a simple conversation or a meeting or an informal conference, or as I said, it can even be alternative dispute resolution. The purpose of these meetings is to rectify the problem to the agency's satisfaction and eliminate the need for additional proceedings. This is appealing to the parties because it avoids the expense and possible later appeals. In the enforcement area, if a settlement cannot be reached, the agency can issue a formal complaint against the violator. Then you get to the hearing process. It's a trial-like arbitration procedure before an administrative law judge. Administrative law judges have different names. I think I have a slide on it. But essentially it's a judge that is through the agency, and the process is trial-like, except that there's limited discovery, no jury. The rules of evidence are sometimes not completely or entirely applied. The parties are entitled to be represented, and there are other due process requirements such as a record being made, a decision in writing by the hearing officer, and certain appeal rights. Okay. So, under the Administrative Procedure Act, before the hearing takes place, the agency must issue a notice that includes the facts and law on which the complaint is based, the legal authority of the hearing, and the time and place for the hearing. The ALJ presides over the hearing and has the power to administrate oaths, take testimony, rule on questions of evidence, and make determinations of fact. The ALJ works for the agency, is not an independent judge. However, there are things that make for the ALJ to be unbiased. Okay? So what are some of those things that make for administrative judges who are not Article 3 judges to be independent or quasi-independent? First, ALJs are assigned to cases in rotation in most instances. So you don't get to pick your judge, and the judge doesn't know what case they're getting, so as to avoid any appearance of impropriety by having the agency have control over who the judge is. Second, judges can be removed for good cause only. So in other words, if they rule against the agency, they can't be fired because of that. It has to be for good cause, which is a much higher level than that. So judges have the independence to rule as they see fit. Third, their salaries are set by the Civil Service Commission so that agencies have no control over their salaries. So the salary cannot be held over the ALJ's head as a means of controlling the ALJ to give favorable decisions to the agency. And finally, ALJs are selected from a list of qualified applicants prepared by the Office of Personnel Management, not by the agency itself. Okay. So sometimes they're called ALJs, administrative law judges. Sometimes they're called administrative hearing officers. Sometimes hearing examiners. Sometimes referees. Sometimes presiding officers. And of course ALJs. And they can administer oaths, issue subpoenas, make decisions concerning evidence, take or cause depositions to be taken, control the hearing, hold settlement conferences, dispose of procedural requests and similar matters, make or recommend a decision or other actions consistent with the APA. A recommended decision usually means that the decision of the hearing officer goes to a higher official in the agency who then either agrees with the decision or disagrees with the decision. If they disagree with the decision, then it can be taken to court usually. Okay. If they agree with the decision and the decision is adverse to the party, then that can be taken to court. Okay. So as I said, the hearing resembles a trial. Sometimes discovery is allowed, sometimes it's not. A lot of that's controlled by the procedures set forth by the agency and or by the hearing officer. It has to comply with the APA procedures and must meet constitutional standards. The burden of proof is on the agency. The person affected by the agency action has the right to present testimony, including their own, to cross-examine witnesses, and to present evidence. Hearsay is usually allowed in these types of hearings, although the administrative law judges are usually either required or knowledgeable enough not to place as much weight on the hearsay as they would on non-hearsay evidence. So after the hearing, the ALJ issues an order or a decision. Either party can appeal that. Most of the time it's an appeal within the agency to a higher level. And then if displeased with the final agency decision, you can go to court. If no party appeals, it becomes a final decision. After a period of time, it's non-appealable. And that is usually set forth in the statutes of how long you have to appeal the agency's decision. Okay, so if a party appeals and the case is reviewed, the final order comes from the highest level of the agency. So the holding in the Chevron case basically says, as you see in the red down here, that the court should defer to an agency's interpretation of the law as well as fact. And the agency's interpretation that the statute was reasonable. So generally, the court is only going to overturn the agency's decision in two situations. One is where the court finds that the agency did not follow its own regulations, or the regulations were unconstitutional, or they were acting adversely or not in accordance with the statutory requirements. So that's what we call a kind of legal error made by the agency. The other is factual, and the general rule for agency law is that as long as the agency's decision is supported by substantial evidence, then the court is not going to overturn it. Only if the court finds that there was not substantial evidence to support the decision of the agency will overturn the agency's decision based on the facts. And that's a very heavy burden to overcome. Very rarely does that occur. Okay, that completes part 4 of chapter 23. The magic word for chapter 23 is regulation.